Good morning, everyone. We're just going to give it a couple minutes to have a few other attendees join, and then we will go ahead and get started. All right, well, thank you. Good morning again. Welcome to the Construction Lien Rights in Michigan Overview webinar. My name is Rebecca Wenglinski. I am the Director of Marketing and Business Development at Kerr Russell. Before we get started, there's just a few housekeeping items that you'll see on your screen. We're going to have everyone muted throughout the entire webinar, but you can submit questions. You will see a drop down on your screen for a question area. Go ahead and submit those. We will be looking at those throughout the entire webinar. So if there is a question that is pertinent to a slide, we'll be sure to get that over to our presenter. You can also always raise your hand when we do open it up for some Q&A at the end, and I'll be able to unmute you at that time, and you can ask your question at that time. Everyone will receive the PowerPoint and forms referred to in the presentation by the end of the week. So if anything should come up, just feel free to go ahead and let us know with the email address that was in the contact information here at the end, but you should be getting that at the end of the week. Presenting today is Mike Carroll. Mike is Kerr Russell's lead attorney on construction law. For more than 25 years, he has represented subcontractors, suppliers, general contractors, and owners on a variety of construction project legal matters, including the area of liens, which will be discussed today. Before we jump over to Mike, I would like to turn it over to Jim Chase for a few comments. Jim, I'm trying to unmute you. There you go, Jim. Now you're unmuted. Sorry about that.
All right. Thanks, Rebecca. Just wanted to take a second on behalf of NECA to welcome everyone to this program. As I'm sure you know, this program is on construction lien rights in Michigan. We have a pretty good sized group that are tuning in for this program, so I hope you all enjoy it. With that, I'd like to turn it over to Mike. Mike?
Okay, great. Thanks, Jim. So folks, this seminar is kind of a how-to file your construction liens. And so to give you a little outline of what we're going to be going over today, we're going to talk about notices of commencement, notices of furnishing, the claim of lien itself, and how you file those things. We'll touch briefly on sworn statements and then waivers. And then at the end, I'll go through the sequence, a summary of the sequence of events that have to occur in order to properly perfect your liens. So that is an outline of the slides you'll be seeing today. But before we go into the nuts and bolts, I want to back up just for a second and talk about what a lien is, because I'm not sure it's very intuitive for many of us. So a lien is something that attaches to property. In this case, we're talking about real property. So an example would be like a tax lien. If my wife and I failed to pay our taxes, the authorities could file a lien on our house. And that would be in the form of a piece of paper that would be recorded at the Register of Deeds. And so it would cloud my wife and the title to our house. And that's a scary tool if you're the owner, and a good tool if you're the person, the creditor, seeking to get paid. So another example of a lien is a mortgage. We all have mortgages probably, and you know, when you go to sell your house, that mortgage pops up on the title. It's clouding the title, if you will, if you've ever heard that term. And you know, before you sell, that creditor is going to have to be taken care of in order for him to discharge that lien. So in our case, it would be Bank of Ann Arbor would need to get paid off before we'd be able to sell the house in order for their mortgage, their lien, to be discharged. So, and with these types of liens, just like the construction lien we're about to talk about, they can be foreclosed upon. So if my wife and I didn't pay the Bank of Ann Arbor, they could come in and foreclose on the house. That would take place in the form of a lawsuit initiated by the bank against us. And at the end of the lawsuit, they'd be seeking a judgment of foreclosure. And then the house would be sold at a sheriff's auction up at the circuit court building. And the highest bidder would get it. And the bank would be paid out on their lien, hopefully from their perspective, out of the proceeds of that foreclosure sale. So these construction liens that you folks have access to are just like that. They go on, they attach to the real property, they cloud the title, they're an encumbrance, like a mortgage. If the owner were to try to sell that property while your lien was still valid, it would pop up and the buyer would see it, and the title company would require that you be paid before the property could be sold, you know, unless some kind of a workaround was done with insurance. But and then also with regard to a construction lien, you can foreclose on it, which means you'd begin a lawsuit to take the property really from the person, to have it sold at auction, and hopefully have your lien paid out. So it's a very valuable tool. It's interesting that it exists for you folks. You're quite unique in this regard of being subcontractors in the construction industry. This type of a lien doesn't exist, for instance, in the auto industry. If you were a lower tier, you know, tier 3 supplier in the auto world, you don't get a lien like this that allows you to hopscotch the person you're in contract with and try to collect against someone that's further upstream from you. So it all came about, actually, every state in the nation has liens, and all of them are old. In Michigan, they date back to the 1800s. And so why that is, I think, is because we've all heard the stereotypes of like car salesmen not being trustworthy, and there's that stereotype of builders kind of taking the owner's money and absconding with it, running off and not paying the subcontractors, leaving people high and dry. Well, there must be some truth to that stereotype, because all the way back in the 1800s, they created these lien rights in all the states, and in Michigan in particular. An important piece of legislation was in 1890, when they called it mechanics liens, by the way, back then. But if you hear people talk about mechanics liens, it's the same thing really as these construction liens. Our current statute has it more accurate. It's called a construction lien now, but you may hear some people still refer to it in mechanics liens because other states still have that nomenclature, and we used to here in Michigan. But the legislature thought it was important enough to protect really people like you folks. You're really kind of the target audience, but also the owners, if they follow the Lien Act correctly, to protect those two classes of persons from the builder that would run off with your money, apparently on occasion. So it's what I want to emphasize, though, folks, is it's a second set of rights that you're lucky enough to have. It provides you a separate avenue of collection of a debt. It allows you to file this lien, to gum up the title of the owner whose property you're improving, and potentially, therefore, collect from that second bucket, that second avenue of collection. but your first avenue of collection still exists. And that's kind of what I want to say at the front end here. Your contract is with a general usually. The Walbridges, the Bartons, the Chrismans, or whomever. That's who, your account receivable is with. That's who you contracted to perform the work, and that's who owes you on the contract. That's your first avenue. This lien thing is this second route to protect you, hopefully collect on the debt if something goes wrong with the contractor. But 9 times out of 10, it's even if there's a dispute or some reason why you're not getting paid initially, it resolves through your relationship with the contractor. Maybe they thought you didn't do something right, or maybe they're slow paying you because they had some other thing go wrong with the project. But usually at the end of the day, you work through those issues with your customer, and that's who pays you. But it is nice, just in case, to have this second set of rights that the Construction Lien Act provides you. What it really does in the practical world is give you leverage over that general, in my experience. And sometimes even the threat of the lien is actually a tool. There's the threat of the lien, and then there's the filing of the lien itself. So, for instance, I've had clients before on General Motors projects, and General Motors doesn't want you to lien their property. They're a big, 500-ton gorilla, and are very resistant to that. And they scare essentially their generals into taking care of it immediately if it were to happen. So sometimes on projects, if you just start calling your customer and say, hey, I'm coming up against the end of my time frame in which I need to file a lien, that threat can help cut through some of the red tape or whatever the dispute might be. And by the way, that period, it's very important to know, and I think probably most of you already do know this, is that period within which you need to file a lien is within 90 days of the last date of work. So that's the most crucial deadline of them all. You need to file within 90 days of your last date of work, or you don't have the right to file the lien at all. But back to my point, your rights versus the customer never go away. You always are able to pursue them. So let me illustrate that point by trying to share with you what the suit would look like when and if you had to begin foreclosure of the lien. So I'm jumping ahead. You've had problems with your customer. You're not getting paid. You decide to lien. Like I said, most times either the threat of the lien or the filing of the lien will lead to discussions that will hopefully get you paid. But in the odd time it doesn't, you need to decide whether to begin suit, and you only have 1 year to do that. So although most people who are unpaid for going on a year wouldn't wait any longer anyways. So heaven forbid you're in this situation, you need to start the lawsuit. That suit's going to look like this. So let's say I am one of you. Let's pick Ferndale. I'm Ferndale Electric, and I would start the suit out. I'd say County of Oakland or wherever the project is. I'd go Ferndale Electric as the plaintiff, and then I'd have the versus. And then the next entity I'd list would be your contractor, your customer. Let's say it's Barton Mallow. Because the first count in your complaint is going to be for breach of contract against that entity. They're the person that primarily owes you. And then you're also going to list below Barton's name the owner, which could be, Showstack, or often it's just some meaningless, words like XYZ123 Co., let's say. And so then your second count in the complaint, after you've laid out your breach of contract action, is going to be for foreclosure of your lien against the property owned by XYZ123 Co. in my example. And then ultimately, if, again, heaven forbid, the case doesn't resolve the dispute, because usually you go through a mediation or something and everyone finally, realizes who's to blame and who's not, and compromise is reached and you're paid, almost all cases settle. But in that unique instance where the case did not settle, you'd be proceeding to trial or the culmination of the case where you ask the judge for a judgment of foreclosure of your lien. So it's just like a mortgage. And then that judge would order the sheriff to sell the property at an auction. And then hopefully, if you have all your ducks in a row, that the proceeds of that sale be used to pay off your lien. So that's kind of the end goal of the whole lien process. That doesn't really happen that often, that the lien goes all the way through foreclosure and sale. One time I was surveying my partners, and between the three of us, we had, I think it was 80 years of construction law experience. And yet between the three of us, we only knew of a handful of events where there had been a sheriff's sale and the property had been sold pursuant to a lien foreclosure action. So, and that's against thousands and thousands of liens that we filed, over that time frame. So it is somewhat rare. It's really kind of this threat that it provides, because no owner likes to have a lien on their property. It's leverage to get yourself paid is really what it's all about. But you do want to know how to do it properly, because it decreases your leverage if you don't do it properly. And in heaven forbid that, kind of once in a lifetime awful situation where you need it to work in order to get paid, you wouldn't want it to be screwed up. So what I've found is that generally if the general contractor is solvent, then you don't end up needing to go the whole way against the owner. So one would hope, your typical customers like Barton and Walbridge and Chrisman and the like and Clark would, there's no real fear for them going out of business, so that you're ultimately going to be able to deal with your counterparts from your customer and work through whatever issues are existent and get paid. There was one example of a local contractor that I think was relatively well thought of, John M. Olson out of Grosse Pointe during my career, that did go out of business. And Mr. Olson did actually flee to the Bahamas, and folks were left holding the bag. So, I mean, it has happened. And in those instances, you would want to, have your liens properly perfected so you could turn to the owner of the property for recourse. And then the other time it comes up is when you have a pay if paid clause, which many of you with the sophisticated customers you have do get stuck with pay if paid clauses. Now, a lot of times, even then though, there is room for dispute that, perhaps the general was partially paid for your work, and the reason the owner's withholding the balance is because of, whatever the defect or the argument is that's holding up payment in general. But the worst case scenario is you have a pay if paid clause in your contract with the general, so they don't have to pay you unless and until they're paid. And they truly haven't been paid yet, which again is somewhat rare. And then, your rights really end up being just against the owner. And then the worst case scenario is that owner then goes out of business. And that's what happened on the Bloomfield Park project of many years ago. I think Alpha Electric was the electrician that got the worst of that. But the contractors on that project all got some pittance on their liens. They only got something like 14 cents on the dollar. So that's the worst case. You have a pay if paid with your general. They have truly not been paid, and then the owner goes out of business, and there's a bank asking for its money back and all you lien claimants. But again, very rare that happens. Generally, between your rights against the customer and these lien rights we're going to be talking about, you're in really good shape as an industry. You guys are really kind of blessed to have this extra set of lien rights. Okay, yeah, still on this slide, Rebecca. The second point on this first slide is that these lien rights are only against private property. So if you think about it, they wouldn't want you, the electrician or the plumber or whomever who has a lien who went unpaid on a public project to be able to foreclose on that. We wouldn't want, you guys to own City Hall or the plumber to own the public school, that's the subject of a public project. So long ago, back in the 1800s, they disallowed the liens against any public projects, and that's where the bond claim body of law comes from. Bonds basically replace liens on public projects, and bond rights are kind of a separate subject that I could give a whole separate seminar on that I'm not going to go into today. But in any event, just know that your lien rights are only good against private property. Okay, Rebecca, let's go to the next one. All right, I want to talk about definitions under the Lien Act. So the Lien Act is a series of statutes which frankly are kind of hard to read. There are other statutes I might direct you guys just to Google and you could read for yourself. They're fairly plain English, like the Builders Trust Fund Act is one that's really short. It's only about 4 or 5 sections and it's just perfectly clear what it means. The Builders Trust Fund Act I mentioned only in passing. That is yet another different legislative angle that has been provided to you people to collect on a debt. And under the case law, under that statute, it actually allows you to go after individuals at the customer who made the decision about paying persons other than yourself. The Trust Fund Act says that a contractor who receives funds from an owner must first use that to pay subcontractors and suppliers before anyone else. And as I mentioned, the case law actually allows you to reach the decision maker who holds the checkbook at the customer to potentially claim against him or her if they failed to pay the downstream vendors like they're supposed to. So that's actually a third different angle that you folks have available to you. But that also would be the subject of a different seminar. I've given that seminar to different groups before. And actually, I know some of you on this call have been there for that, but I'd be happy to do that again if Mr. Chase. That's a different topic for a different day. The reason I mention it though is that is an act that you can actually Google and have a good chance of understanding everything. This Lien Act, I'll tell you, I can't really say too many nice things about it. It's archaic, it's difficult to read. You could Google it and look if you wish, but I'll tell you, it's a real bummer to have to try to slog through. It's kind of got like Middle English almost in it, and you have to read the whole thing to hope to understand it at all, and it's a real pain. But anyways, in the beginning of the statute, they'll give you some definitions, and I wanted to focus on a couple of them with you. An owner is a person who has the fee interest. So, or it could be this land contract vendee, as you'll see there on the slide, which doesn't come up very often. So what is a fee interest? My wife and I, for instance, own our home as fee simple owners. That's kind of the broadest type of description of ownership you can have. Now, we still hold it subject to a mortgage, and we have, easements for utilities on it. So if you were to pull our title, you'd see that we got it from, Bob and Sue Smith in 01, and that, Mike and Teresa Carroll own the property. And then you'd see mortgage and you'd see these easements referenced on the title. And so when and if you file a lien, that also would then pop up on that title of the owner. So that's known as owning a fee and fee simple. And that's the easiest to comprehend when you're liening someone. If Teresa and I had used a plumber and failed to pay him, that plumber could lien our house, and that's a fairly simple scenario. A little more complicated is if the person who contracted for the improvement is a lessee. So lessee is kind of everyone else. For instance, someone with an option to buy a property, an optionee, fits within this definition of lessee. But the more typical scenario is a true lessee, a tenant on a property. And the reason I bring this up is it could be the tenant that contracted for the improvement. So a classic example in my experience is the shoe store at a strip mall at 7 and Mac had some people help with the build out, and then they wanted to lien, the shoe store. Well, what's odd about that is when you file a lien, it encumbers the interest of the person who contracted for the improvement. So again, with Teresa and me, it would be our whole house, and that would be very effective. But with the shoe store, really your lien would just encumber what that tenant, what rights that tenant had in the real property, which are, described by his lease with the landlord of the strip mall. So that renders your lien a lot less valuable, because if you were to foreclose on the shoe store, then you'd have to take up the balance of his lease, have to pay the landlord the rent, and you wouldn't get his inventory necessarily. So now you just have a space in a mall, and you're a plumber, or in our case electrical subcontractor. That doesn't really do you a lot of good. So and this can be quite disheartening to clients when I inform them of this, that their rights against a tenant aren't as great as they would be if they were against the fee simple owner. So I kind of wanted to mention that. I would still, though, always lien, folks. It's still really valuable to lien, because like a 90-odd% of cases work out, and it's nothing but good leverage to employ. So it's a right you folks have, and you should always, even when it's a tenant situation, employ it. I'll tell you a war story. I had a project in Brighton very recently, just concluded, and it was a huge facility. The tenant was making pills for pharmaceutical companies, and so it was this kind of really sophisticated space with a lot of HVAC and other things involved, and my client on that was the mechanical guy, and so he had a huge amount of money owed, as did the general and the other trades, from this tenant. And we were trying to pressure them into paying, and ultimately they entered into a payment plan and finally did pay our folks off. But the tenant's lawyer was saying to the judge, she had us back in chambers for a settlement conference, and of course she wants the case to go away, so she's kind of working the sides to make us get off her docket and hopefully settle. And he had told her that my lien was only of so much value because he's just a tenant. What am I going to do? Take over his tenancy? And she came to me with that. I said, well, first of all, Judge, don't. She said, Mike, your lien doesn't have much worth. What are you going to do? Take over this tenant space and become a pill manufacturer? I mean, that's not likely. The landlord owns the property, and your lien's not valid against them. So, well, I said, first of all, Judge, don't say that in front of the tenant, because I'm trying to pressure him into paying us, and I want him to be fearful of me taking this, his tenant space, right? So, and then I said, furthermore, Judge, there's a lot of money at issue here, and nothing's impossible. So, we could get a receiver involved, and that receiver could hire the types of people with PhDs that would be necessary to run this outfit. So, we could take over that lease. We could take over the business, and we could run it. In that instance, there was the opportunity to do that, take over the business. So, nothing's impossible. And then that story did end well through the pressure that we applied. The tenant did ultimately make all its payments to us. So that ended well. But I guess my point there is, even when we're in this lessee situation, the leverage is really good of the lien to scare people, because they obviously didn't want to give up their cash cow, the business, to a receiver or to us foreclosing on even that tenancy. Okay, next slide, please. And then a few more definitions. So contractor is the person in direct contract with the owner. Subcontractor is that person at the next tier down, supplier as well. The reason I'm showing you this is that these are the definitions under the statute, and sometimes someone that looks and smells like a trade subcontractor, a specialty subcontractor, can be a quote-unquote contractor under the act. And that's in a situation where you are in direct contract with the owner. So sometimes when there's a construction manager, and it's the type of construction manager we call an agent, construction manager agent, where they kind of have a contract off to the side with the owner, but the owner holds all of the trade contracts directly with you, folks like you. That would be a situation where under the Lien Act, you would actually qualify as a quote-unquote contractor. In my experience, that's usually a little more on the public side, like university work. It seems that the Bartons and the Wallbridges managed to just have a construction manager agency relationship with the owner, and you have a direct contract, so you can't really lean on those. Those are public, but it does affect your bond rights, which are kind of similar to lien rights in terms of this tier discussion, whether you're in direct contract or not, can affect your rights. And so that's kind of the point I want to make about this. The main thing I would take out of this is, as to whether you're defined as a quote-unquote contractor, is whether or not you have to give your notice of furnishing, or on the bond side, whether you had to give your notice, your 30-day notice under the bond. And if you're in direct contract, you don't have to give the notice. But in all other times, in the more typical scenarios where you folks are, one tier removed from the owner, where there's a general between you and he's the person that has the direct contract with the owner, then you do have to give the notice of furnishing. Which kind of brings me to the discussion of the nuts and bolts on how you file your lien. So there's this, what I call kind of a complicated dance that is set forth in the different things one must do in order to perfect a lien. There are dance steps that have to occur both from the owner's side for him to protect his rights, and from your side in order for you to protect your lien rights. And those are made up of the notice of commencement, the notice of furnishing, and the claim of lien primarily. So the first step, Rebecca, we can move on to the notice of commencement slide. The first step in the dance is the owner's. If he wants to protect himself under the Lien Act, he is supposed to file a notice of commencement, and it's supposed to contain the information shown on your slide. Now there are red lights and there are yellow lights, as one of my senior partners once described to me, for you folks in the Lien Act. And why I say that is the Lien Act is, it even says it right in the Act, it's supposed to be liberally construed to protect the likes of you guys. And substantial compliance with the Act is, it says it right in the statute, is allowed. So if you just kind of substantially comply with some of these requirements, you may still be okay, which I'll touch on as we go forward. The only one that you can't kind of get by with, oh shucks, I tried, is the 90-day period for the filing of the claim of lien. That one is a real red light. If you screw that up, you're done. There's no getting around that. But many of these other things, like notice of furnishing, as we'll discuss, or if the owner were to screw up and not file his notice of commencement, those I would qualify more as yellow lights. They might be a problem, but you might be able to get around them. So let's look at a notice of commencement form. Okay, here's how one might look. You may have seen these before. You get these from the owner. It is supposed to tell you the legal description, which is important because when and if you are going to file a lien, you need to have that. That's what the Register of Deeds goes off of. They don't go off of people's names. They don't go off of street addresses. If you want to file a lien, you need to have that legal description. It might say lot 21 of, Beaufay subdivision, or it might be meets and bounds where it says, 384 feet west from such and such. But whatever it looks like, you need that in order to do your lien. Okay, and then number 2, it talks about the party contracting for the improvement. And then you see below there for 3, the fee owner. So that throws people off when they're filling out the forms. They're like, what's fee owner mean? Well, as we discussed, there can be instances where someone like a lessee contracts for the improvement, and that would need to be put forth in paragraph 2 of this form. And then you also get to know who the owner of the real owner of the property is, the landlord in that instance. Sometimes they're the same people. Most often they're the same people. If my wife and I were contracting with someone, it would say both of our name under both those 2 categories. And then owner designee, you see the word designee sometimes in dealing with the Lien Act, and that is someone the owner can designate to receive notices. So if it's a big enough project, the owner may have hired Jones Lang LaSalle or someone like that to be the owner's representative. That might appear there. Sometimes they'll put their architect in there, or it'll just be kind of the managing member of the LLC that's owning the property. And then there's the general contractor, and then there's a statement that follows, which you can just scroll down, Rebecca. This is required by the Lien Act. It's something alerting people like yourselves that you might have lien rights. So that's it for that slide, or that handout, Rebecca. And these handouts are going to be provided to you, those exhibits, that form that we just looked at. You folks on the webinar will be provided a copy of all the forms that Rebecca will be showing you as we go through this, as well as actually my PowerPoint that we're running through. So with regard to the Notice of Commencement, the owner is supposed to record it at the Register of Deeds in the county where the improvement's being done, and he's supposed to keep it posted at the site. And then this next bullet point's the important one for you guys. If you want a copy of the Notice of Commencement, you need to send a request by certified mail. So in a perfect world, the accounting staff at your company would know to send out that request via certified mail for the Notice of Commencement right at the beginning of the project. The supply houses are really the KE electrics and lumber companies. They have people in accounting departments that are trained to do these steps. This is the first one that is incumbent on you folks to do, which is to send out a certified mailing requesting the Notice of Commencement. The next one is the Notice of Furnishing, which we'll get to in a minute. And I have gone out and trained clients, personnel on how to do this, because between the lien projects and the bond projects, it can get a little bit confusing, but I think I've come up with some ways to kind of dumb that down as much as possible, or make it as kind of universally applicable, I guess is a better way of saying it, a series of steps that could protect you on both public and private projects. And so I did give a training to a mechanical equipment supplier and their staff not too long ago on how to do that. So I would make myself available for that to any of you, but also some of you may already be ahead of the curve on that, and this may just be a refresher for you, which would be great. So the one thing though you want your staff to do in a perfect world would be send out this demand for the Notice of Commencement, so you get it back so you know how to do the Notice of Furnishing. All right, let's go on, Rebecca. Now, the key thing about, from the owner's perspective, if they fail to do the Notice of Commencement, that extends the time within which you as the subcontractor needs to provide your notice of furnishing. So a notice of furnishing is a requirement for you folks, you know, when you're a second tier like you normally are, when you're a subcontractor to the general, who is the person who has the direct contract with the owner, you're required to give a notice of furnishing. If the owner doesn't do his step in the dance though first and doesn't provide you within 10 days of a proper request, a copy of it, then that does extend the time within which you must do your notice of furnishing. Okay, next slide, please. You know, and there can be this supposed penalty for a general that fails to give you the notice of commencement, but it's kind of toothless. They supposedly have to pay you your costs for having had to track down the correct information about the owner and the legal description that you couldn't get because he didn't give you the notice of commencement. But I've actually never seen anyone proceed under this. I mean, when it comes time to lien, you need to know the legal description, but there are ways of finding that out besides the notice of commencement. You can do a title search, or, you know, my staff, the paralegals, will go to the city taxing information, and usually the person who pays the bills for the taxes, there's a legal description and a fee owner there. So there are different ways to get to, you know, who and what you're liening, and to then come back after this general contractor under this provision to ask for your costs. I actually never seen anyone bother to do that. Okay, so next slide. Okay, so what is the notice of furnishing? It's a notice to the designee. We saw that word designee earlier, basically to the owner, that you're out there. And the reason that it makes sense that you need to do that is the owner might not otherwise know about you, okay, because his contract is with the general. So at your tier, and maybe even tiers below you, or if you happen to be a couple tiers down in a certain situation, how is the owner to know about you unless you give a notice of furnishing? Once you do give them that though, now you're on their radar, and they need to take into account you and you getting paid as they move forward through the payment progress. So with every pay application going forward, after you've sent them a notice of furnishing, they know about, let's use this Ferndale, they know about you, that you're out there. And they won't be forgiven for ignoring the fact that they know the general's supposed to be paying you, and they're supposed to be able to track that the general's paying you. So it's a very valuable tool, and one that the remote people, when I say remote, people that aren't in direct contract with the owner, need to give to the owner. And here's the information that it must contain, basically who you are, what you're providing, you know, where the property is, and who your customer is. So let's show the handout, if you would, please, Rebecca. And so the handout is the form that my firm uses. It matches the statute, which really kind of sets forth what you're supposed to say. So at the top, you send it to the designee or owner. Designee is that word we saw on the notice of commencement that tells you who they expect you to send your notices to, and then the contractor. And then these blanks are the things that I mentioned you're supposed to fill in. The legal description is usually contained in an Exhibit A, and you say who you are and what you're supplying and to whom. So this, okay, actually, we're not going to go to that page, Rebecca. Let's go back to the PowerPoint, please. All right, so the important part is the next slide, Rebecca, which is when, well, who must serve we've covered. Anyone who's not in direct contract with the owner. And then how you serve it, you have to do it by hand delivery or certified mail. Okay, and next slide, please. Okay, and here's the kicker. You gotta do it within 20 days of the first work. So that's the second piece, that if you were operating perfectly in this lien world, you'd have people trained at the company to as we discussed, send out that request for the notice of commencement by certified, and then following up on the information provided, sending out the notice of furnishing within the first 20 days, or at least within the first 20 days after having received back the notice of commencement. So both by certified mail, by the way. So that would be the perfect scenario if you had your staff trained to be able to do that. That would protect you the most. Why I say that would be perfect is a lot of times with some members of this group, you don't always lien that often. The supply groups have to lien more often, so they usually have accounting wired to do this. But I've run into situations with many a contractor before, including some of you electrical subs who don't have to lien very often, so they usually are calling, me or their attorney at that juncture, and they haven't done the notice of furnishing. What I would say is, no matter when it comes to light that you haven't yet given a notice of furnishing, just do it then. It's better late than never. I've had some scenarios where I try to think through, oh gosh, my client didn't give the notice of furnishing. Should I bring light to that by sending it now? Everyone knows it's way past 20 days after the start of the project. Well, I can tell you that there's never been a scenario where I concluded it would be better for the client not to send the notice of furnishing. So that's the benefit of my experience on this. Better late than never. Always send it the minute you figure out it hasn't been sent. And this this notice of furnishing thing is one of those yellow lights. I would like for you to all be perfect and always send it out timely. But I'm kind of realistic. I'm kind of realistic in my experience. It doesn't happen all the time. And if you fail to do it, this is one of those that I would call a yellow light rather than a red light. Remember, the only red light is the 90-day period after last work that you have to file the claim of lien in. And the reason that it's only a yellow light is your failure to provide a notice of furnishing only defeats your lien. And it can defeat your lien. If you're remote and you didn't do the notice of furnishing, that's kind of what the concern is that your lien rights will be negatively impacted, maybe even lost. But what I want to say about that is the only way your lien is defeated for failure to provide a notice of furnishing is if in the meantime the owner has paid pursuant to sworn statements. So it's always better to get it in because you don't know necessarily whether the owner's already paid for your work to the general. And you don't know whether he did it right. He needs to have done it, quote unquote, pursuant to sworn statements and waivers. And Lord knows that the owners on their side don't always follow all these steps absolutely 100% accurately. So even if you're late, it might be okay. And what I want to share with you is an experience from kind of the other side of the coin on that. We were representing DeMattia back when they were still a going concern, a general contractor, and they were working on Domino's, and a subcontractor below them had gone bankrupt. And so that subs and suppliers liened the project. And because Domino's was a big client of DeMattia, DeMattia was stepping in and handling the lien claims for the owner and was going to have to pay them if they were valid. And I got tasked, I was a junior associate at the time back in the 90s, I got tasked with going through the sworn statements to try to prove that the owner had indeed already paid for each of that subcontractor and his subs work pursuant to sworn statement in order to try to avoid the liens, because sure enough, several of those subs had not filed notices of furnishing at the beginning of the project like they were supposed to. This is kind of like a common thing that lien claimants failed to do their notices of furnishing. Again, with this type of seminar, we hope to get you to where you don't ever fail to. But what I want to kind of say is that if you did happen to fail to do the notice of furnishing, all is not lost. Because in this example, when I was on the other side of the coin trying to defeat claims like your folks's would be, that was a terribly monumental task. I had a whole conference room at the law firm with, you know, each of these pay applications and sworn statements, and trying to follow through, you know, to prove that recalcitrant sub, the bankrupt sub and its subs had already been paid was really difficult. And so the point of that being, from the other side of the coin, on your side of the coin, you're always kind of, once you're into a dispute situation where you haven't been paid, frantic and thinking, oh gosh, I didn't do the notice of furnishing, you know, and you're worried sick about it. And like I said, you first thing you do is send it off to, you know, as soon as you realize you haven't. But I kind of tell you that story to maybe, you know, take the edge off that panic for you, because from the other side of the coin, it's really kind of hard to prove that, you know, your failure to provide the notice of furnishing defeats your lien. So, and that's why I call that a yellow light. Okay, let's move on to the next one. Okay, now when you do the notice of furnishing, the other thing that your staff has to be trained to do is to fill out a proof of service. And go ahead and click on the form for that, Rebecca. So this just stays in the file, guys. So you've sent the notice of furnishing off to the owner and the contractor, and then on my form, it's the second page of the form. You fill out this with the certified numbers for, you know, the green card that you sent to each of them. And I think it's got a notary block at the bottom, Rebecca, if you go down. And then you just stick that in the file, guys, because you need that proof of service. If ever you need to file a lien, that needs to be attached to the lien. So that's kind of the third form I draw your attention to, besides the notice of commencement, the notice of furnishing, and this proof of service. Okay, let's move on to the next slide, please. All right, and here's the big dog, the claim of lien. There's the thing about the 90 days. Basically, this whole slide just tries to tell you the importance of filing it, because the lien ceases to exist otherwise. And this is one that their failure to do the notice of commencement doesn't save you. Actually, you can go to the next slide before. You can either click on the claim of lien now, Rebecca, or, okay. When you folks are asking me to fill out a lien for you, I've got it down to, I ask for 7 data points. The first and last dates of work need to be put in the lien, so that's 2 data points. The legal name of the owner and the legal description of the property, which we've seen you should have from the notice of commencement if you've done everything properly. But otherwise, my firm has to scramble, or if you were doing this yourself, you'd have to scramble and try to figure out what those 2 are. And then the last 3 pieces of information is the total contract amount, which you're allowed to include extras. You're allowed to include good faith extras that haven't been reduced to change order. That's always something that the clients do. But less than already been paid, which should then result in the amount owed. Of course, half the time the clients give you those 3 figures, they don't all jive, but we have to make it so. And so those are the 7 points that you need to fill in the lien form. And so now would be a good time to look at the handout, Rebecca. You might have to go back, yeah. Okay, so at the top of this, if you don't mind, Rebecca, what's funny is the first thing that they have you fill in is the date of the first date of work, which might throw you, because normally you'd be putting like today's date at that top of a document, but that first blank is actually, if you read through the whole thing, is supposed to be the first date of work. And then you have your company name, your address, the project you're improving, and then you got to have the legal description, either in this space or attached as Exhibit A. Then you list the owner and where his address, if other than the property, is. Then you got a line for the last day to work. And then that next series of blanks relates to your contract amount, how much you've been paid, and so on and so forth. So this form we'll provide to you guys. And our notary block down there actually is a little bit expanded from that which appears in the Lien Act, which is a little more stripped down. And in the past, Wayne County's been a little bit of a pain in the butt to accept filings, so they required this little bit more verbiage. So we just put that on all of our forms now. That's probably overkill for Oakland or some of the other counties, but that's a handy little tip with regard to that. So let's go back. Okay, so what's the next slide, Rebecca? Okay. What I want to emphasize with regard to the lien filing deadline of the 90 days is that it is very strict. For instance, you wouldn't want to rely on mail to send it in. There's a case where someone mailed it in, then there was some kind of snafu, the mail didn't get delivered, they got notice of it, and they sent it in by mail again. This is all before the 90 days expired, but it didn't get there in time, and so despite all those kind of good faith efforts, they lost their lien because the 90-day is such a harsh deadline. Unlike with the notice of furnishing or a sworn statement or some of these other things, you might be able to be a little late or show that you tried and substantially complied. The lien filing deadline is a harsh one, and so I will share an anecdote. Last holiday season, our client knew its 90th day was on January 2nd. And so that's the day after New Year's, obviously. And so kind of with the holidays, we were going back and forth, and they, were a little bit slow getting me the information, and then, having to sign it and so forth. It came down to the last day. So nowadays you electronically file. So my secretary was electronically filing it that morning of the 90th day, and it wasn't being accepted. And then ultimately we got on the phone with someone at Oakland County Register of Deeds, and they informed us that they they had a computer meltdown and were experiencing a 1 or 2 day delay in items that were submitted being recorded. So I stroked out and jumped in the car and drove up Telegraph to Pontiac and got there at 4:27 and ran into the office at 4:29 before they closed, and the manager stuck around to help me, and she stamped, good old-fashioned hand stamped my filing, and and just to show you that I'm not paranoid, she said to me, she said, well, we discussed this with the computer system being down, and we decided that the only way to protect yourself if you were on the last day would be to do what you did, which is to come in and get proof that you were here. Because sure enough, the next week when I got back my lien from the electronic filing system, it was stamped the next day, the 3rd, which would have been the 91st day, and would have led to a huge hassle trying to submit affidavits and stuff that we'd sent it in the day before, and I don't know what would have happened. So I provide that anecdote to kind of just inject into you a little bit of that paranoia that I have, that if heaven forbid you're filing on the last day, you better be ready to drive it up there the old-fashioned way, just to make sure you can prove you got it there on time. And another thing about the lien I want to talk about briefly is the risk of overstatement of the lien. So I mentioned that you can put in the lien your contract amount, and then you can put in good faith extras. So say you had a $100,000 contract and they gave you 10,000 in change orders. So you both agree, you and your customer, that you're owed 110, or I'm sorry, that the contract amount is 110,000. And then let's say you've got submitted some requests for change orders for another 5,000 they haven't accepted, or that they're fighting with you about. You'd still put in that 5,000 into your contract amount. So you'd be going for 115,000 in my example. Your contract for 100, the approved change orders for 10, and then that 5,000 that you've submitted, but there's a dispute about, as long as it's in good faith, that's okay. Then you would indicate to the reader in the claim of lien what you've been paid to date and then the corresponding amount still owed. But what you don't want to do is overstate your lien purposefully. That could result in the lien being dismissed. So I usually preach caution if people are thinking about adding something else that doesn't qualify as a good faith extra. The fear is that the whole lien could be dismissed. I mean, if it's a clerical error, often they'll just be, the court will decide that they're just revised down to the correct number. But the fear with overstatement is you lose the whole lien. So just a word to the wise on that. Okay, and let's click on the proof of service for the claim of lien. So like with the notice of furnishing, when you file the lien, you have to serve it, by the way, within 15 days. That's another of these deadlines in the sequence of events. But that is probably another one that's just a yellow light. Meaning if you were late, it might not be the end of the world. But when you do send out the lien, you need to fill out one of these proofs of service. Now, often the clients will have my law firm do the lien, like in that example I shared with you where I had to drive out to Oakland, and then so my secretary will fill this out. And like the other one, fill in the certified numbers of to whom it was sent. And you hold on to that in your file as well. Why that is because when you go to finally, if you ever have to sue to foreclose on a lien, you need to have this item attached to your complaint according to the statute. So these proofs of service are necessary documents that you need to keep in your file as you proceed through this this dance that we've been talking about. Okay, I think if we go back to the slides, that might be it for the claim of lien. And so we're almost done, folks. I'm just going to go through a few more things and then provide the summary of the sequence. Okay, I want to touch briefly on sworn statements. That's a document that's supposed to be submitted to the owner by the general that lists people like you and how much you've been paid and how much is owing on this current payment application and how much remains on your contract. And that's a means for the owner to be able to track you, especially if you've given them a notice of furnishing. They're kind of obligated to track you and make sure you're taken care of out of each draw. And then you folks actually are, many of you are of sufficient size that you're asked for these actually by your customers. And so you may be familiar with them for having had to fill them out yourselves and listing all your subcontractors and suppliers. So yeah, let's look at the handout on that. Okay, here's one that my firm, I drafted that matches what the statute requires. It's really kind of verbatim. So deponent's going to be you. You would circle subcontractor usually for an improvement in whatever county, and then either insert the legal description if it's small or attach it. And then these categories, I've included all of them that are in the statute, but you don't, I mean, the labor and labor fringe benefits and withholdings usually doesn't appear on most people's. So you're citing the name of the sub, the type of improvement furnished, the contract price, how much you've already paid, and what's currently owing. And then at the bottom, you need to have someone sign that under notary. There can be criminal infractions for intentionally defrauding people by what you insert in the sworn statement, so it's always important to be careful with the information you provide in there. Now, let's go to the next slide if you don't mind, Rebecca. So when it needs to be provided, basically it needs to be provided when you're asked for it or when you're applying for payment. And then most certainly it needs to be provided before you file suit. So this is another thing that, clients come to me when the dispute has begun and they don't get in them there that often, and For instance, they'll come to me when it's time to file the lien and we're closing in on the 90 days and they haven't done a notice of furnishing. I'll just shoot off the notice of furnishing for them, like on day, let's say 88, and then file the lien for them with the proof of service of the notice of furnishing attached to it the next day. Because as I mentioned, it's never too late, better late than never with regard to the notice of furnishing. And then with regard to the sworn statement, a lot of times people haven't done those. Again, if you're on these more sophisticated projects, you may have been doing them with each pay application, but a lot of times my clients haven't done them yet. And at the latest, I need to send one out before I file the suit. And that includes for you guys as subcontractors. Okay, let's move on. This basically says why you have to do it. You can't file a complaint without it. Okay, let's keep going. All right, then the other big red light that's more usually with your lawyer than it is you, although you need to be aware of it as well, is that one needs to file his suit to foreclose on his lien within 1 year of the recordation of the lien. So in my example I gave you where I raced out to Oakland County on January 2nd, that means that on January 2nd of 2021, I have to have filed the complaint in court to foreclose on the lien. Otherwise, the lien becomes invalid. So that's a hard deadline. That's good for you to be aware of, but usually at that point you've got this in the hands of your attorneys. Okay, let's move on. When you do start a construction lien foreclosure suit, one of the requirements of the act is that you name everyone else that has an interest in the property. So in my example of the plumber liening my house, he would have to name Bank of Ann Arbor because they would show up on the title search as having an interest. And again, this is a little bit more for the lawyers probably than you folks. Okay, let's move on. Also, we have to file a notice of lis pendens that there's an ongoing suit, so that also clouds the title because there's the lien, but then the people going to look at the title wouldn't necessarily know if you followed through on the lien with a lawsuit. So you want to file actually these notice of lis pendens. It's another piece of paper that shows up on the title that indicates that you did indeed proceed through with a lien foreclosure suit. Okay, let's move on. All right, and briefly on waivers. So you're all probably familiar with waivers on projects where, before you receive the payment, it's a conditional waiver. I mean, often it's a partial conditional waiver that you give to the general and he submits with a pay application. Then he gets paid by the owner, pays you your part, and the next month they'll look for a partial unconditional from you saying, yeah, I got the money. It's unconditional, my waiver. I'm not conditioning my waiver on receipt of any payment. And then perhaps you'll give a conditional waiver for the next month's draw saying, but I am owed this next amount coming out of this next draw. So here's a conditional waiver for that saying, conditioned upon my receipt of that money, I'll waive my rights. Now, a lot of times if there's a dispute, we'll get it resolved, and then I'll have the general or the owner say to my client, all right, give me a full unconditional waiver. And so the advice is kind of underlined here for you guys, and you may already be on top of this, but you wouldn't want to give them that full unconditional waiver until you have money that cleared the bank. So cashier's check, that's almost infallible. That would be fine. I usually have to tell my clients, you can't really give them a full unconditional until that money that paid you has had a chance to clear the bank. So once in a while, clients would override that recommendation for me if they trust the person they're dealing with. But certainly that's always my advice. So let's go into the waivers so I can show you some examples of these. So here's a full unconditional, and it says in the 4th line down, by signing this waiver, all our construction lien rights are waived and released. All right, now let's go to a conditional one so I can show them. Do you have the next waiver in line? I just kind of want to highlight for you folks the kind of the magic language for the conditional piece. Okay, so it's funny, this reads the same as the unconditional one, folks. It says, by signing this waiver in the fourth line there, all our lien rights are waived and released, but the key part is that next sentence. This waiver is conditioned on actual payment of blanks. So this is what you'd give if you were going to settle and they didn't have it in the form of a cashier's check or cash. You'd give them a full conditional saying, okay, we waive all our rights, but it's conditioned on me actually getting that last 50 grand or whatever is at issue. And then that protects you. That little sentence there protects you in giving them the conditional waiver, that it's conditioned on that happening. If it doesn't happen, you haven't waived anything. So I just kind of wanted to show you folks the difference between unconditional and conditional. So, okay, we're almost done. Let's move on to this. I want to give a summary of the sequence of events. All right, in this dance. So number one, you send out the notice, the demand for the notice of commencement. That's almost always for you guys. You wouldn't have to if you were in direct contract, but when I'm giving training, I kind of, like I was saying, try to make it kind of universal. I would just send it out regardless. Why take a chance in trying to interpret whether your contract's direct or whatnot? If I were training, for instance, my staff on this, I'd ask them just to send it on every project. And on the bond side, at that same time, you'd send a demand for the bond. So you could even get potentially a letter that covers both bases, or probably more likely you just want your staff to be able to appreciate the need for sending out a demand for the bond for those projects that have them, as well as this lien law demand for notice of commencement. So anyways, in liens, that's the first step. You send out the demand. Okay, then next step is a notice of furnishing that we've talked about quite a bit today. It's supposed to go out within 20 days of your first providing labor or material. So if you were trying to train someone, you'd want them to be aware of that 20-day mark. It can be extended by the time it takes for the owner to get back to you with a notice of commencement. So within 20 days of getting that back is actually kind of the extended deadline. But again, if you want to simplify things, you can send the notice of furnishing before you get the notice of commencement. You can figure out who the owner is. I mean, usually you kind of know it's Tiffany's, that's having you do a build out, and you have an address for them. So you can send a notice of furnishing even before you get the notice of commencement back. All right, the third item is that proof of service, a notice of furnishing that you need to fill out and keep in your file that we went over. Okay, let's keep going. Okay, the fourth is if you're in the situation you haven't been paid, recording the construction lien, and one must do that within 90 days after you last provide labor or material. So the one thing about that is there can be some dispute if it's warranty work or not. So you're technically not supposed to be able to use warranty work to calculate your 90 days. I would say as long as you have a good faith basis for arguing that the work you were providing was in furtherance of the base contract, that you could use that date as your last date. Because the way that the courts have interpreted what is warranty work seems to kind of go both ways. Sometimes they act like something that sounds like warranty work is not, and other times they'll characterize something that's more like punch list work as warranty work and act like you were too late. So, the sooner the better, obviously, for filing your lien. If when in doubt, I'd use an earlier date if you still have time within the 90 days. Okay, then the next step, number 5, is service of the construction lien. That is by sending it by certified mail, and that has to happen within 15 days after the recordation. And then the 6th thing is to fill out the proof of service and keep in your file that you did send out that lien. Okay, now the next slide, Rebecca. The 7th is a sworn statement that you have to provide before you start suit. Okay, keep going. And then you need to foreclose on a lien within 1 year after it was filed. I don't think there's anything after that, is there, Rebecca? Okay, that brings to a conclusion my speech on the nuts and bolts of filing a lien.
Thanks, Mike. So we will turn it over to the attendees. If anybody has a question, just go ahead and raise your hand and I will go ahead and unmute you. Also knowing that you will be receiving the slides and forms in an email later this week. If there are no questions, we'll go ahead and close it out. Thanks again, Mike, for presenting, and thank you to Jim for allowing us to present to Nika. Have a good day, everyone.